A mother's emotional bond request, allegations of victim intimidation, and a defendant struggling to explain failed drug tests. This courtroom hearing had no easy answers.
She has absolutely no criminal history the last 13 years or so. She does have an old OWI matter. She would avail herself of any, both a scram and a GPS tether if the court thought that they had to care for her disabled mother.
Calls the case of the people versus Danielle Pressey.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Pressey, who's approaching Judge. What's your name?
Danielle Pressey.
Requesting an adjournment.
Yes, Your Honor. There's a lot of discovery to go through.
May 29, 2025, 9 a.m. Bond continued.
If I could be heard on bond, Judge.
You may.
Thank you. Judge, I did have a chance to talk with Ms. Pressey. She is here before the court with a bond of, I think it's set at $150,000 cash. This is a situation where she has absolutely no criminal history the last 13 years or so. She does have an old OWI matter from 2012. That's all I could find on her CCH. She resides in the Metro Detroit area in Oxford or Lapeer. She owns a business, a brick and mortar business, a nail salon. She's not a flight risk in any way. She cares for her disabled mother. She is, like I said, gainfully employed. She owns a business, a nail salon that she is the proprietor of. She is we'd ask the court to consider some kind of a reduction in bond, hopefully a personal bond. She would avail herself of any, both a scram and a GPS tether if the court thought that was beneficial to ensure both her presence and that she's not anywhere that she should not be. She has, as I said, work, family responsibilities, and have to care for her disabled mother.
Response.
The facts of this case involve the defendant traveling around 60 miles an hour. It's on Marks Road, which I believe is 45, but it's probably 45 would be my guess. 60 miles an hour with now candidly the BAC was 0.038, but there was also 200 nanograms per milliliter of amphetamine, as well as THC, 2.7 nanograms of THC in her system. The victim is tragically the defendant's son, I believe was 7 at the time. He was improperly belted in the rear seat and killed in the accident. The vehicle crashed into a tree. Based on those facts and circumstances, I don't believe that the bond is improperly set. I believe that the facts of this case are awfully tragic, but I am concerned about the defendant's potential conduct while out. This matter ending in a serious incident.
Yeah, if I might, this is a very serious situation, very tragic. There was, the allegations of the purported Adderall, I believe, was a prescribed drug. As Mr. Childers stated, it was a 0.038 was the reported drug or alcohol. This was, like I said, this was a situation where I don't think she comported herself. This accident happened several months ago. She's comported back in December, I believe. She's comported herself properly since then. She'll continue to do so. As I said, she's not a flight risk in any way, and she does have responsibilities. While we, there's a lot of information to look at here, and I believe this is a matter that is going to be litigated. pretty heavily. So I'd ask the court to reduce the bond.
Motion for bond reduction is denied. The court does consider the defendant a risk to public safety, and so our bond will continue. Thank you.
Thank you. Your Honor, if we did put together a written motion, would the people waive notice on that?
No, I'll wait notice as long as you don't give it to me at the end of the day on Wednesday.
No, I don't do that. Okay.
As long as I have a fair amount of time to respond to the
Court consider hearing it early as well, Judge?
It will. When we receive the motion, Ms. Wagner will be more than happy to give you a date to hear it.
Thank you, Judge.
Court does call the case of the people versus Jordan Dave.
I'm sorry, Judge. I didn't catch the adjourned date. My fault.
29.
Thank you.
Court does call the case of the people of the state of Michigan versus Jeffrey Murphy.
Good morning,
Ray.
Good morning, Your Honor. May it please the Court, David Burgess on behalf of Mr. Murphy.
Ray Tanha, aka the phone.
Again, Your Honor, I apologize. Someone dared call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just. All right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting exam be held.
No.
People have their witnesses available the 27th?
Your Honor, if I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn the defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victims. Not that they should be anywhere, but certainly places that have put her at risk. They have since been taken down, is my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again. And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right. So these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to
All right.
action.
You understand that, sir?
Yeah. Yes.
All right. And Mr. Burgess, you're going to have a more detailed conversation with him about that?
Yes, I will, Your Honor. I'm well aware of what Ms. Tanner will do if that's the case. If he does it again. If it happens again, if it did happen in the first place, Your Honor. So.
All right. Very good. Okay. And with the people
That's a good day, Your Honor.
that will work.
Thank you, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. We recall that previous case. Apparently I wasn't clear,
Okay.
if you don't mind.
You weren't clear? Okay. I guess, can we get, court recalls case, people versus Jeffrey Murphy.
Frank House is the prosecutor. Turn your back to people.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All right. Thank you for coming back, Mr. Burgess.
Yeah, of course,
Yes.
Your Honor.
Thank you, Your Honor, for recalling the case, and thank you to Mr. Burgess for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir,
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of this crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. So you understand that? That you're not, and when the court is saying no contact, no intimidating or threatening behavior, that applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you, Mr. Burke.
Yes, of course, Your Honor.
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. I have a bond violation report here.
But I haven't even been out a week to get my system clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCIP, what's that?
It's inspection stuff.
No, oh yes, they rescheduled my appointment for Monday at 9:30 with the brown guy for the outpatient program.
Yeah.
Yes, because I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was going to come back.
Because I haven't dropped clean yet, that's why I assumed that I don't know how long it takes to leave.
You're still using.
No, I'm not.
No, because you want, okay, I'm going to tell you what. You're telling me you're not. I'm going to take you back. I'll call over, get levels, and then we'll see exactly what's happening.
So I got
You want me to do that?
so I can drop today?
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff. I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay.
This courtroom hearing featured 3 serious cases highlighting how judges balance compassion with public safety. The most emotional involved Danielle Prezi, whose request for a bond reduction was denied despite her clean record, business ownership, and family responsibilities, as prosecutors argued the tragic crash involving her 7-year-old son raised significant public safety concerns. The court also warned another defendant over alleged intimidation of a victim and addressed a separate case involving repeated positive drug tests, ordering further verification instead of accepting the defendant's explanation. Together, these cases showed the court's commitment to protecting the public, enforcing bond conditions, and making decisions based on evidence.